2008. The government was divided, as the High Court later said, quote, a rather peculiar feature of this case, end quote. The Health Ministry supported the petitioners on the ground that Section 377 was counterproductive in the fight against HIV/AIDS. The Home Ministry supported the law. And the new law minister, the same man who later refused to ban Lalaveld's Gandhi book because he actually read it, conceded that the law was probably outdated. In July 2009, the Delhi High Court struck down Section 377, holding that it violates Article 14 of the Fundamental Rights section of the Indian Constitution, which guarantees all citizens equality before the laws and equal protection of the laws, as well as Article 15, non-discrimination, and centrally 21, right to life with dignity and a right of privacy, as we'll see. The case was heard by two of the High Court's most respected judges, Justice A.P. Shah and Justice Muralidhar, both known for the quality and the progressive character of their opinions. The NUJS Foundation opinion is very long and unusually complex, given the number of distinct legal and factual issues involved. Because the later reversal fails to confront these arguments, I have to lay them out now. In general, what's particularly impressive about the opinion is its thoroughness. It cites many social science findings and a huge number of legal judgments, both from Indian courts and from courts abroad, as well as a wide range of international documents. This aspect of the opinion can't really be reproduced here. The opinion's over 100 pages long, but you should imagine it. But a succinct summary of its major arguments is now going to be attempted. Throughout the opinion, the acronym MSM, Men Who Have Sex with Men, is used, thus bypassing irrelevant questions about whether we're talking about acts or orientations. The opinion is written as if the targeted group is entirely male, and nothing at all is said about lesbians or whether Section 377 has ever been used to burden their rights. In Britain, in fact, lesbian acts were never illegal, and maybe that's the reason why they feel they can ignore that. So I'll follow the logic of the opinion, but I do note that narrowness. First, history. The court repeatedly delves into the history of Section 377, insisting, as I already have, that its foundation is Victorian and Christian with no basis in Indian traditions. Because India was more liberal than Britain in matters of sexual orientation, the court notes, many people came to India to take advantage of that liberal atmosphere. Therefore, in 1960, when Lord Macaulay drafted the Indian Penal Code, he felt a need to be harsh, introducing this idea of offenses against the order of nature. But that was a Western concept, quote, based on a conception of sexual morality specific to the Victorian era, drawing on notions of carnality and sinfulness, end quote. At this point, the court cites an Australian opinion by the distinguished Justice Michael Kirby, one of my predecessors giving this memorial lecture, noting that a similar law in Australia was, quote, imposed on colonial people, end quote. This history is not legally relevant without further argument, but it does prepare the reader to see a dissonance between India's own self-imposed constitution and the vestiges of empire that remain in the penal code. As the NUJS court says, quote, there is no presumption of constitutionality of colonial legislation, end quote. Next, facts. Since the Supreme Court will subsequently overrule the Delhi High Court on the findings of fact, an unusual thing for a higher court to do, we might expect to see sloppiness in the factual record. Nothing could be further from the truth. Buttressing its argument with wide-ranging citations from empirical and scientific studies, some of which were made available to the court in amicus briefs, and some of which it apparently found on its own, the court draws three important conclusions. Number one, the illegality of consensual same-sex acts harms public health to efforts to curb the spread of HIV/AIDS by discouraging MSM from seeking treatment and testing. This is the primary emphasis of the factual argument, and detailed factual analysis was presented to the court in an affidavit from the National AIDS Control Organization, affirmed by the government's Ministry of Health and Family Welfare. Further data were presented in an amicus brief from the Lawyers Collective. The court notes an opposing argument by the Home Office to the effect that criminalizing gay sex will help the struggle against HIV/AIDS by deterring homosexual acts, but it concludes correctly that there's no evidence supporting that contention and a great deal of evidence against it. Second, the illegality of same-sex acts has led to violence against gay men, including violence by the police. This section of the opinion draws on a wide range of affidavits involving gang rape, police violence, custodial torture, and other offenses. 3. The illegality of same-sex acts is associated with feelings of low self-esteem and humiliation. This argument, buttressed by psychological studies from many nations, lies on the border of fact and norm, but the fact of such feelings will later prove relevant in reaching the normative conclusion that dignity has been violated, so I include it here. So now to constitutional argument. The court makes 3 constitutional arguments. I'll begin with 2 briefer arguments that actually occur later in the opinion in order to dwell on the pivotal Article 21 argument. Addressing Article 14, equality before the law, the court reviews the history of the requirement that a law's classification must be founded upon an intelligible differentia and one that has a rational relation to the objectives of the law. Arbitrariness is excluded, as is an objective that is itself, quote, illogical, unfair, and unjust, end quote. But, argues the court, Section 377 does not take account of relevant factors such as consent, and its classification is based upon, quote, disgust toward a particular social group or animus. Its classification is therefore, quote, both arbitrary and unreasonable. As to Article 15, discrimination, what needs to be argued is that discrimination on the basis of sexual orientation amounts to discrimination on the basis of sex, since sex and not sexual orientation is mentioned in the constitutional text. The view that sexual orientation discrimination is a form of discrimination on the basis of sex has frequently been urged in the legal academic literature. After all, to criminalize a consensual act because its participants are 2 men rather than a man and a woman is in the most straightforward sense to discriminate on the basis of sex. U.S. courts have, however, been rather reluctant to accept this argument. Some state courts have accepted it, but the U.S. Supreme Court never has. However, here, the Delhi High Court does accept it. The court mentions that the Canadian Supreme Court agrees, but they then proceed to offer an independent argument for the conclusion. First, they say, a primary purpose of anti-discrimination norms is to prevent individuals from being judged by gender stereotypes. But that's exactly what Section 377 does. Furthermore, a series of prior cases dealing with discrimination against women contain language implying that all cases dealing with gender stereotypes must be subject to strict scrutiny, which Section 377 will not pass, as we'll see. Now, Article 21 provided the court with its central line of argument. The basic idea is that if it is established that a law burdens a fundamental right, the law can only survive if the state can demonstrate a compelling governmental interest. This basic tenet of Indian constitutional law was set forth very clearly in a series of cases that the court extensively cites. There are 2 fundamental rights at stake, the right to privacy and the closely related right to life with dignity. Much is said about the intimate relationship between privacy, especially sexual privacy, and full human dignity. These rights are not explicit in the constitutional text, but they had already been recognized over the years through interpretation of Article 21. Now, I have to provide some history, as the opinion does also at this point. Since Article 21, as written, says only, quote, no person may be deprived of his life or personal liberty except according to procedure established by law, end quote. No mention of privacy and none of dignity. At the time of the framing, India deliberately sought to limit due process to the procedural, since Ambedkar had learned from his study of U.S. history that substantive due process, as in our Lochner era, could be used against laws friendly to labor. So in place of the words due process of law, which occur in our Constitution's 14th Amendment, the document reads only procedure established by law. However, as time went on, the need for substantive due process began to be felt in 3 areas: limits on police behavior, since India's constitution lacks an analog of the US Constitution's Fourth Amendment banning unreasonable searches and seizures. Second, limits on criminal punishment, since it also lacks a direct analog of our Eighth Amendment limiting cruel or unusual punishments. And finally, sexual privacy. India has gradually followed the US in using due process to craft a privacy right that is used in all three of these areas, including the defense of some areas of sexual privacy. The court in NUJS Foundation goes into the details of this gradual recognition of the privacy right. They then argue more briefly that Section 377 burdens this right, which they root in the word liberty in Article 21. As for dignity, the word life in Article 21 had long since been interpreted to mean life commensurate with human dignity, and the court gives this history as well. Then, by alluding to the factual record of stigma and discrimination, they argue that this right as well is burdened by Section 377. They mention that both the right to equality and the rights to privacy and dignity belong to all, just in virtue of their humanity. A compelling state interest must therefore be found, since the court has already disposed of the flimsy claim by the Home Office that Section 377 helps public health, which the Health Ministry had denied. The only remaining interest is supplied by popular sentiment. So the court now argues that a compelling governmental interest can never be supplied by a majority moralism that subordinates a class of persons. Popular morality, they note, is distinct from the morality embodied in the Constitution. And the Constitution makes the courts guardians of the fundamental rights, including and especially, quote, the fundamental rights of those who may dissent or deviate from the majoritarian view, end quote. At this point, the court quotes some well-known words of Dr. Ambedkar against majoritarianism. Thus, the court reminds its audience of the way in which the heinous practice of untouchability was held in place by majority sentiment.